I don't know what to say. Is all of that true? All of what Peter said? Not so much. But one thing I do want to say, when Parita introduced Peter as one of the founders of ACS, I think back to the days I think it was in my office, when Peter first dreamed of this organization. So I think he was the founder. We were talking about whether it could take hold in a conservative era, which we already knew we were entering. I was not as optimistic as Peter, but I now certainly share his pride, because even if all I had to do with it was being vaguely connected as Peter's teacher, I'm proud to have anything to do with one of the major sources of hope for America's future. You know, yesterday at lunch, when Senator Biden said he was accustomed to people not listening to his speeches, because after all, he's a senator, and therefore he gave us all license to eat while he was speaking, I was imagining that tonight, in order to make sure that I could hold the audience, not being a Supreme Court justice and all, that I would arrange to have you all eating still while I spoke. And I was ready to say that I didn't mind at all. On the contrary, I thought it was a sign of affection that you would eat while I was speaking. I, after all, have a Jewish mother. She's almost 90. But ever since I was born, she always said, if you love me, eat, eat. But I no longer can say that, since you're all just sitting here. And I have no excuse for not saying something you will actually listen to. Well, I want to offer you a 3-course meal. Hopefully it won't be very long. An appetizer, sort of a salad of what I think are ultimately platitudes, also known as what is it okay to ask a Supreme Court nominee? And I'll talk about why one has a right to get beyond platitudes. Then an entree, sort of a mixed grill of attitudes, also known as why worry? Why should we be worried when this bright fellow is nominated to the court? And I do plan to talk about this bright fellow, John Roberts. I understand that he's been a kind of shadowy figure lurking over the assembly, and that none of our prior speakers, not even the fiery one you heard at lunch today, actually talked directly about the nominee and what there is to worry about with him. And I plan to do that. And then a dessert, tonight's special, an Are We Alone flambe, also known as When Did It Become a Sin to Pay Attention to the Rest of the World? So to begin, what is it okay to ask? Well, I'm glad you asked me that question, Senator. No, the well-framed question is actually a high-wire art form. Consider the scene when then-attorney John Roberts came before the Senate Judiciary Committee 2 years ago as a nominee to the D.C. Circuit. Senator Orrin Hatch of Utah was the chair, and when Senator Hatch didn't like Senator Schumer's detailed questioning of the nominee regarding, heaven forbid, his substantive views about specific constitutional matters, Hatch leaned over and whispered loudly into the mic, "I feel badly saying it between you and me, but I do know dumbass questions when I see dumbass questions." Well, presumably smart-ass questions would be out as well. Too tricky. Plus, Roberts would outsmart the smartest ass in the building. Well, should a senator pose no-ass questions? Pitching the nominee softballs like, "Tell me, Judge Roberts, do you appreciate the limits of the judicial role? Or would you prefer, other things being equal, or ceteris paribus, as we say in the law, to usurp the roles of Congress, the President of the United States, state legislatures, and make up law from the bench to advance an extreme, non-mainstream, weirdo ideological agenda?" No need to rush, Mr. Roberts. Take all the time you need before answering. I thought I was going to use that line more or less as a joke until I saw an AP release filed Thursday afternoon, this Thursday, just as I was starting to write some of the ideas that I was going to cover. It had the caption, "Roberts assures Democrats he won't be an activist." Wow, I thought, how reassuring. The recipient of that revealing commitment was Senator Ben Nelson, Democrat of Nebraska, one of the reputed leaders of the Gang of 14. As you know, 7 Republicans and 7 Democrats who together negotiated the truce that avoided a nuclear clash over the Democratic plans to filibuster some of the lower court nominees of President Bush recently. He said he would not be an activist judge, Nelson observed. Now, I'm told Nelson was already leaning a little bit toward the nominee, and he leaned a bit harder after that frank exchange. But he had reserved final judgment, he said, until after the hearings. Perhaps suddenly the nominee would say he would be an activist. And just the day before, while also reserving final judgment, and after making an issue of the White House decision to invoke attorney-client privilege with respect to the memos that Roberts wrote as the political deputy solicitor general in the second Bush administration. By the way, interesting question whether he was counsel to the president or counsel to the United States of America, but I'll pass that over. After making an issue of that, Senator Chuck Schumer, Democrat of New York, said in a speech at the National Press Club, "He told me flatly that he is not an ideologue. He said that he shares my aversion to ideologues." So there. And I wondered, have we learned that little since February of 1982, when a memo to the Reagan Attorney General William French Smith urged him never to defend the conservative credentials of Reagan appointees and thereby risk, quote, criticism from the left and even the center. Better, said the memo, and I'm quoting from this memorandum, which was unearthed from the National Archives, to shift the debate to whether Reagan's judicial nominees have, quote, a proper appreciation for the judicial role. Shift the debate. And this was long before Berkeley's George Lakoff was teaching everybody about the vital role of reframing. The memo was written and signed by John Roberts, who had just turned 27. Pretty scary for a kid in his first post-clerkship job. And from what President Bush and Fred Thompson and the others responsible for conducting the present show have said, this is to be their spin this time as well, with almost no change. That this nominee has strong views is obvious, and it's his right to have them. That those views are the ones that the people who voted for George Bush and for a Republican-led Senate should have expected the president to seek in a justice is obvious too. They're right when they say, what did you expect? Who did you expect us to nominate? What should be no less obvious is the playbook from which Roberts will be taking his cues and making sure that you don't learn those views. In the National Archives, you can find a memo describing how Justice Sandra Day O'Connor was prepped for her confirmation hearings. Here's the advice that memo said O'Connor was given. It was a retrospective memo written at the end of the day. She was counseled, quote, to avoid giving specific responses to any direct questions on legal issues likely to come before the court. Well, what other kinds of issues are likely to come before the court? What other issues would one want to know her views about? What do you think of them Red Sox? I think they're pretty good. The memo goes on, she should simply demonstrate in each response a thoughtful and firm command of the subject area and awareness of the relevant precedents and arguments on each side. And what I found most fascinating about that memo was its author, again, John G. Roberts, Jr. The advice that he gave Sandra Day O'Connor in 1981 person whose seat he is now to fill 24 years later, came from that same young man. And it was at the end of his first day on the job at the Department of Justice as Special Assistant to Attorney General William French Smith. So he knew what the game was about at the very beginning. By then, of course, O'Connor's nomination looked like a fairly safe bet, at least for her supporters, except for the fact that I had read some of her speeches as an Arizona legislator and her opinions as a state court judge, and unlike, I think, any of my liberal friends, I had actually come out strongly in her support in a big interview in People magazine. That was almost the kiss of death, I think, except that she had already been nominated, and there was no way the White House could do anything. I think the memos of that period show some consternation and some worry, but they were going to stick with her, and they had their rule book worked out. There is this difference between O'Connor's paper trail, the one that impressed me, and the paper trail that Roberts left behind, apart from the fact that his is a little bit more star-studded. He went to Harvard rather than Stanford. I think that's a plus, Kathleen. No, it was, he was right up at the top in every way, right? She was third in the class. He was, second or first. But apart from that, his paper trail contains some memos about which I imagine he might be asked some questions. For instance, this morning's New York Times contains a story about a memo that he wrote to Fred Fielding, the White House counsel, in 1983 about whether a new intermediate court should be created to relieve the Supreme Court of about a quarter of its caseload. And boy, did Roberts take off on that. He said, yes, the court is overworked. It then took about 150 cases a year. Now it takes only about 80. Overworked, but only because it chooses to hear so many of the cases that it does. And why does it choose to hear so many? He wasn't satisfied with just being superficial. His memo said it chooses to hear so many because the court views itself as ultimately responsible for governing all aspects of our society. And he went on to say that the court's inability to take on still more cases was good news, because it gives us the same sense of reassurance as the adjournment of the court in July, when we know that the Constitution is safe for the summer. Whoa, I thought. Discussing a proposed constitutional amendment which would have set a non-renewable 10-year term of office for all federal judges. I bet he's glad now that he opposed that one. He wrote that lifetime tenure was more defensible back in the day when judges construed the Constitution strictly. Lifetime insulation from political pressure, though, was harder to defend, he said, today, now that the federal judiciary, quote, usurps the roles of the political branches, unquote. Now, if that memo had been written in the early to mid-1960s, in the heyday of the Warren era, it would have been a little less puzzling. The Warren court was actually engaged in some pretty dramatic decision-making, though I would argue that it wasn't usurping anything. But by the time Roberts was describing the Supreme Court, the court for which he had worked just 18 months earlier, describing it as usurping the roles of the political branches and calling itself a body that thinks of itself as responsible for governing all aspects of the society and a danger to the Constitution when it's adjourned, not a danger, but otherwise a danger. By the time he saw the court in those terms, it had long since announced that it was done with the business of discovering new fundamental rights and new suspect classifications. Those of you who've studied it will recall that I'm talking about San Antonio School Board versus Rodriguez in 1973, and those of you who haven't studied it will know what I mean when you get there. That's a case when the court said, we used to find fundamental rights, and some argue that education should be a fundamental right, but that's not our task anymore. And we used to look closely at whether some way of classifying people ought to be deemed suspect, And we're told perhaps poverty should be a suspect classification. But haven't you heard? We've gone out of that business. And sure enough, the court really had. It had ruled out, by the time Roberts was saying that it was ruling everything, it had ruled out interdistrict busing, it had stopped the creation of constitutional torts, it had come to hold that there is no right to abortion funding, that equal protection strict scrutiny has no application to laws that have a predictable disparate racial or gender impact unless you can show that it was intentional. It had held that not even intermediate scrutiny applies to male-only draft registration or to a male-only statutory rape law. It had upheld the FCC's power to censure stations airing the famous 7 dirty words. It had limited race-based affirmative action in almost exactly the same way that Justice O'Connor and 4 of her colleagues limited it in Grutter v. Bollinger. The Powell opinion in Bakke was really the precursor of the opinion very recently in Grutter. And all of this was in the immediate or recent past when this young man says, we have a court that's wild, it's wrecking the Constitution. So one might well ask, what was left that so badly needed dismantling? What was the court still doing that John Roberts found so dangerous to the Constitution? I mean, I know what I found dangerous to the Constitution. It was the dismantling of the Warren Court's most fundamental decisions. Not all of them, not completely. Vince Blasey was right. Counter-revolution that wasn't. There were details left. But it is telling, I think, of what this young man's landscape was, what he regarded as in need of doing. Now, in his 2000 autobiography, Passion for Truth, Senator Specter, Arlen Specter of Pennsylvania, chair of the Judiciary Committee, wrote that senators shouldn't have to gamble or guess about a candidate's philosophy. Accordingly, should, quote, resist, if not refuse to confirm, Supreme Court nominees who refuse to answer questions on fundamental issues. Don't know if Senator Specter feels exactly that way today, but I think we should hold him to that position. Elaine Jones gave what I'm told was a rousing speech at lunch. I'm sorry I couldn't be there. I was trying to incorporate stuff from this morning's New York Times in what I wanted to say. But she always does. She's dynamite, and she was inspiring, I'm sure. But one question I have, she, I think, issued a kind of challenge to me, if I get it right. Do you still stand by this position you took in 1985, which was then quite radical, that it really mattered what a prospective member of the court thinks, substantively? But it wasn't enough to be brilliant, to summa cum laude, and to have a decent and wonderful character and a terrific personality, but it really mattered whether you were committed to certain constitutional values and whether your sense of the Constitution struck the senators as consistent with what they were entrusted as senators to protect, that it really mattered. And do I still think that? Of course I do. Everybody does. That's what's interesting. It's now conventional wisdom. You really won't find people on the Hill saying, it's not important what he thinks, just that he be smart. What you find them saying is, you can't ask him exactly what he thinks about certain cases because that would be prejudging. They've got a very good routine going there. So the problem is how to get past the platitudes given what they say about the limits on inquiry. Now, we know the formula pretty well from Senator Cornyn and former Senator Fred Thompson. They've been on TV using it, and it comes down to something like this. The nominee should not be expected to answer any question about a specific issue that he might have to decide as a judge. Now, one obvious retort is, why not? Why should we know less about where John Roberts stands than we know about where Nino Scalia stands? It's said that if you appear before Roberts, somebody actually asked me, Tribe, when you appear before Roberts, and they said when, since I think it's pretty fair, he's almost certainly going to be confirmed, doesn't make this process futile. It's incredibly educational. But whether it's if or when you appear, won't you feel strange knowing where he stands on Roe v. Wade if you're arguing a case that involves some aspect of Roe v. Wade? The answer is not at all. I know where Scalia stands on it. I know where Breyer stands on it. I know where all of them stand. They've had plenty of chances to say, and Casey and other cases, why shouldn't I know where he stands? That sounds okay, right? But there's an answer to that I think we should all focus on. And I think it's important to be kind of intellectually tuned in to what this dialogue is that I'm describing, because otherwise you really will be caught sort of somewhat speechless if you're trying to probe and urge others to probe this nominee and you're told, well, you know, you've hit the wall, you've hit the limit. Well, their answer to the question, what's the difference between Roberts and Scalia, is this. The opinions from which you can figure out Scalia's position, after all, were opinions that he rendered after reading briefs and hearing argument in an actual case or controversy, and they had therefore the discipline of being issued in a judicial context. And second, and this is really the more important one, they were not given in the form of pledges made to secure confirmation or election. Because he wasn't making a campaign promise, in effect. Well, the first of those distinctions, he was rendering the opinion as a judge after argument, is basically a smokescreen. I mean, after all, Charles Evan Hughes roundly criticized Adkins v. Children's Hospital in a book that he published, written before his appointment to the court, and then as Chief Justice, he wrote the opinion overruling Adkins. And I don't think we would say that it was improper for him to do that because the book was written without benefit of briefs or oral argument. Hugo Black wrote much of the Fair Labor Standards Act as a senator from Alabama, but later he voted to uphold it as a justice. He didn't make his decisions about the act as a senator in a judicial capacity. So that part of the argument is a make-weight. The part that I think we ought to focus on a little bit more seriously is the claim that we don't want to have people arguing in front of justices who, when they were trying to become justices, basically made promises to various people and maybe to the whole nation about how they would rule on certain issues. That is, if you hold your judicial commission by virtue of your statement during your confirmation hearing that you will do X or that you will not do Y, then, to quote Justice Scalia from his confirmation hearing, he said, if I did that, I'd be in a very bad position to adjudicate the case without being accused of having a less than impartial view because I would have gotten my job through a job talk that made a promise. But the answer to that would seem to be, of course you shouldn't promise to do anything, to rule any given way. Above all, you shouldn't promise not to change your mind. Anybody who says, I believe X and I promise that nothing could change my mind is ipso facto disqualified. Anybody who says, I think Roe v. Wade was wrongly decided and no matter what argument anybody comes up with to the contrary, I'm sticking with it. That's my opinion and I'm sticking with it. Out the window. So nobody's asking you to make a promise to shut your mind. In fact, to John Roberts, one might say, as your boss, William Rehnquist, wrote, in explaining his own decision not to recuse himself in Laird versus Tatum, which was a case challenging a rather nefarious, I thought, government practice of putting disguised FBI agents in ACLU meetings, and today it would be in meetings also of the American Constitution Society, so they could kind of listen in. And the argument was this violates the First Amendment because it has a chilling effect. We don't know whether all the people in the middle of the table are from the White House, but they're all in drag. And Rehnquist wrote the opinion saying that members of the ACS, as it would have then been, don't have standing because at most they're chilled. They're not imprisoned, they're not denied a license, nothing happens to them, so they're chilled. And people said, but, there's a little problem here because you testified at a time when people thought you might be named to the court. You testified when you were head of the Office of Legal Counsel in support of the constitutionality of that law. And he wrote a separate opinion, Justice Scalia recently did, about that duck hunting episode, a separate opinion explaining his non-recusal. And in that separate opinion, he basically said that anyone without preconceived views on legal issues at the time he joined the court would be disqualified by having that blank a mind. You have to be a dodo if you don't have prejudgments on almost every important legal issue that will come before you. So presumably the argument is, but no, the nominee needn't have a blank mind. It's okay if the nominee knows whether he thinks case X should be overruled, probably, or piece of legislation Y is facially constitutional, probably, as long as he doesn't say it, at least not publicly, especially when his getting the position could depend on it. So now we have them in a corner. The position has to be, it's for me to know and for you to find out. What do you want to bet that Roberts is too smart to put it that way? He's not going to say it's for me to know and for you to find out. There are a million ways to formulate it to avoid that. But 4 members of the current court, interestingly enough, appear to take that very position. It is dissenting in the case of Republican Party of Minnesota versus White 3 years ago. Justice Ginsburg, joined by Justices Stevens, Souter, and Breyer in her first footnote, took basically that view, that yes, people may know what they think, but the reason for our practice of not saying what we think is to avoid the appearance of impropriety. In fact, because the appearance of not having made up your mind is part of due process of law, it would violate the litigant's right to a fair hearing in accord with due process if we, at the time we were in effect campaigning for our offices, let you know what we knew. It's a remarkable position the 4 of them took. The majority of 5, in an opinion by Scalia, really don't seem to defend that line. That is, in striking down a rule prohibiting a justice wannabe, one running for that office in Minnesota, from stating, while seeking his or her office, what that candidate's position would be on any legal issue that might come before the candidate. If the person stated that, they would be disqualified. So the rule prohibited them from saying it. And what the U.S. Supreme Court held 5-4 was that that prohibition violates the First Amendment. And what the court tried to do in that case is to maintain the view that a nominee's voluntarily denying to state a position is fine, as we all did when we were up here. As she gets very personal. She says, you, Justice Scalia, and all of us followed this pattern of not saying. What Scalia says is, that's okay. It's okay for us not to say. But there's no public interest compelling enough to force a nominee to keep to that sense of propriety, to force a nominee to be quiet. So you get the logic? It's all right for us not to express preconceptions that we have, but it's not all right for any government entity to put pressure on us to be quiet by saying that if we're not quiet, we won't get the office. The court says the only interest that that would serve is to preserve a phony appearance of not having a preconception on the issue. I think the dissent, however, has the better of that argument. Because if the only interest served by forcing a nominee to shut up about views on issues that might come up is to fool people, and isn't that the only interest served by voluntarily keeping to yourself whatever views you may have formed about Roe v. Wade or about affirmative action? Keep people in the dark. That's not a good enough interest to support the kind of rule that Minnesota had, then it's not much of an interest at all. So the way I come out on this is a little bit complicated. It's if that case is rightly decided, then the tradition of declining to answer questions on issues that might come before you serves only the purposes of deceit and is unjustified. But if, on the other hand, the dissenters are correct, then a ban on announcing your position would be okay as well. And that seems unthinkable, that there should be a government ban in a context like this, telling John Roberts, you must not say what you think about Roe v. Wade, or you will not be qualified for the court. Now, clearly, that whole shtick is too complicated for television. I mean, I'm sure that you all had to work a little bit to stay up with every step. But in the interest of candor, since I believe in saying what I think, I felt I had to go through it. Since it's too complicated for television, what's going to happen is predictable. The senators, who probably will not be adept at putting the question exactly the best possible way, will make it possible for Roberts either to say, you're asking me effectively to make a commitment on how I will vote in a particular case, and I'm sure that people don't want me to do that, or will answer the question because it's so general or so ineptly put that you will only learn from it that, boy, he's smart, and he's familiar with all of the arguments on all sides of this issue. And because he's done other things in his career that show that he's not completely closed-minded and he's not an automaton and not a robotic ideologue, I'm satisfied. That is, he's going to be able, I think, to do that. And not only that, but because he is so affable and because he will come off so well on TV, he looks sort of like a younger Jimmy Stewart or something, he's really going to be effective. I think that it is very hard to imagine the nomination not going through. Now, one temptation is to stop sifting through the 14,000 pages or so of material that the National Archives recently released, and just to go with interviewing old roommates. There's a guy named Robert Bush who was interviewed by the Harvard Crimson for last Friday's issue. Bush, who said he hadn't seen Roberts since the nominee graduated from Harvard College in 1976, nonetheless had, and I quote, many fond memories of life with John, which included playing Nerf football in our room, and some less fond memories, like Roberts' habit of quoting interminably from the 18th century literary critic Samuel Johnson. Bush, whom the Crimson was quick to point out was no relation of the president's, recalled Roberts' inability to do without Pepto-Bismol and his being a, quote, stickler for formality. And this I really liked, caught my eye. According to Bush, Roberts removed Stanford from the list of law schools that he was considering, quote, because the Stanford interviewer was wearing sandals and didn't have a tie, unquote. Good call, John. But in seriousness, the journalists who are working their tails off going through those 14,000 pages are doing an extraordinarily good job, and an important one. You want a paper trail, dude? Have we got a paper trail for you, the mother of paper trails? Those journalists and the senators on both sides of the aisle who are trying to figure out what this guy thinks are pursuing a topic that could hardly be of greater significance. And why is that? Well, this is, after all, a constitutional democracy. Its core values and rights of self-government are mediated by an unelected judiciary. They're not elected, but when they're appointed, there is a moment of confrontation that can also be an opportunity for national learning. Entrusted to that judiciary is the task of enforcing ambiguous texts with ambiguous histories. Those who say that you have to just be able to construe it as though it were a matter of being able to see well enough, to have 20/20 vision. Can you really read the text? Know better. They have to know better. They're not that stupid, nor are the American people. In a recent poll In USA Today, I was pleased to see what a large majority of the American people realized, that the Constitution that is entrusted to these people is ambiguous, and so the kind of people they are, the values they have, the values they bring to it, will affect profoundly what they do with it. People got that. It makes a difference on how they resolve questions, many of which are extremely important in our lives. Here I was quite disappointed, because I liked some of his work, by Jeff Rosen's article in the New York Times last Sunday. The gist of it was, it doesn't matter that much. Chill out. No, there's a lot of other stuff going on besides the court. Of course there's a lot of stuff going on. I mean, the basic policies are made, even though the liberals think we're too stupid to know it. Liberals. The conservatives think we're too stupid to know it. They think liberals believe that policy is made in the judicial branch. The basic policies, how much support for what, going to have health care for all citizens or only for the rich, those basic policy decisions are still hammered out in the political branches. But to say that what the court does is of marginal importance is stupid. To take, and it's something that someone as smart as Jeff Rosen shouldn't say. Take one example. People like Rosen who say that cutbacks in the abortion rights protected by Roe v. Wade and its sequels wouldn't be that important, because they would merely return more responsibility over abortion to the states, and in most of the states, abortion would remain legal most of the time. Well, first of all, that doesn't give much weight to the rights of the women who are stuck in the states that are going to be more reactionary on the subject, and who may not have the resources to find legal and safe alternatives elsewhere. But it's worse than that, actually, because people who say it will all be returned to the states are just incanting a mantra which they should have realized a while ago is false. Think about it. The transaction between an abortion provider and a patient is an economic transaction. Even in Lopez, when the court struck down the Gun-Free School Zones Act, there was a clear majority, indeed, as far as I could tell, at that time, all but Thomas, who took the position, and Rehnquist was on board with it, as was Kennedy, as was O'Connor, who took the position that Congress can regulate all economic transactions, however local, on the recognition that we've got a national economy. Okay? In Gonzalez against Raich last month, the court reaffirmed that position and went further still. Not only could all economic transactions be controlled, like the sale of drugs, but the possession of drugs could be controlled because it was in some way related to economic transactions. Only 3 dissenters, Rehnquist and O'Connor, no longer liked the implications of that concession in Lopez, and they, of course, were joined by Thomas, who said openly that he thinks the clock should be rolled back to before 1937. Did it make any difference that California had a more liberal regime for medical marijuana? No difference. Gonzalez v. Raich holds that Congress can preempt the field. The states have no option. So add 2 and 2. The cutback of Roe plus Raich means, as soon as Congress wakes up to see it has this power, that conservative Congress can ban any abortion procedure it wants, subject to whatever the new subtracted Roe looks like. That is, if Roe v. Wade is reduced to some shriveled version of itself, that will be all that binds the Congress as well as all that binds the states as a matter of due process. So Congress will at that point be able to ban, usually I'm sure under some gruesome sounding name to make it saleable. So if it's not going to be called partial birth abortion, they want to make it even earlier. They will call it impending birth abortion or what have you. Ban the procedure and what abortion procedure after the first few weeks isn't gruesome when you look at it in detail, ban the procedure and say explicitly we're preempting all state law. So the idea that it's just going to be returned to the states, while a fond hope and not even adequate in itself, is also fallacious. But that's just one example. If you follow the trail, you will find that in most of these areas, if there is any significant cutback from where the court is now, and the court has already cut back very dramatically, the implications will be rather severe. So that's the appetizer. Now, a little bit of grilled entree. That shows that there can be some rather sad consequences, and the question is, what's there to worry about? We've got a nice young man, young as justices go, super smart, hardworking, polite to the core, decent, sweeter than Scalia. Why worry? And so far I've said nothing to suggest that his own views, so far as we know them, are scary, although I must admit the memo that indicates he was scared by the role the court was playing even as of '83 scares me. Well, to be blunt, there are at least 7 worries, and I obviously have too little time for a 7-course meal, so I will just pass some of them in front of your noses. You get a quick whiff, and then whisk them away, while others I'll linger over just a little bit longer. Worry number 1 is of the whiff and whisk variety. It doesn't mean it's unimportant. It's rather important, but I won't say a lot about it. It is that Roberts might differ too much to the president in things like the handling of supposedly unlawful combatants, like Mr. Hamdan, whose trial by military commission on the president's say-so, with no review of the reasonableness of the classification, Roberts joined a 3-judge D.C. Circuit panel in upholding shortly before his nomination was announced. This week, the White House blocked a Senate vote on a measure sponsored by such radicals as McCain of Arizona, Warner of Virginia, and Lindsey Graham of South Carolina, that would have taken the modest step of defining what illegal combatants are, establishing ground rules for interrogations, and prohibiting cruel, inhuman, and degrading treatment of prisoners in violation of treaties and other laws. The White House thought that was much too deep an invasion of the president's prerogatives. Remember, this is a White House that treats the president as fundamentally above the law when he acts in the name of the war on terrorism. And I think one should be worried, simply worried, not there's no conclusive evidence that this is the case, but there's ground in the Hamdan decision that Roberts joined that there's a problem here. Reason to think, to put it mildly, that the White House, believing that it's so important that it remain above the law that it will not even allow this mild piece of congressional legislation to pass, would take care to pick a Supreme Court justice that at least it believes would vote to keep things that way. So worry number 1, the White House may have guessed right. Worry number 2 is that Roberts might be a reliable, solid vote, just like O'Connor in this respect, but with an added 25 years of shelf life. Reliable, solid vote for the narrowest possible reading of Congress's Commerce Clause authority. The problems that we face as a nation are ones of profound interconnectedness. You know the slogan, think globally, act locally. It now almost certainly has to include act in a centralized enough way so that no contributor to a global problem, however local, will escape regulation. I was going to say some stuff, but I will just save it for another occasion about global warming. You know about that problem. At first, the president said it didn't exist. Then he said, well, maybe it exists, but not serious enough for us to join Kyoto. Well, if you're interested in global warming, you've got to read Elizabeth Kolbert's wonderful 3-part essay in this spring and early summer's New Yorker magazine. But I guess only if you really want to be scared, because it does show that we are on a very dangerous path. It shows that if current trends continue, carbon dioxide levels will reach double the pre-industrial level by the middle of this century, and that today's levels are already so high that the last time they were in this range was 3.5 million years ago, during the Pliocene warm period. One scientist with the National Oceanic Administration said, it's true we've had higher CO2 levels before, but then, of course, we also had dinosaurs. It seems that the Earth is now warmer on average than it was at any point in the last 420,000 years. A few degrees more, it will be hotter than at any point since the human species evolved. With a rise of about 4 degrees, which is on the low end of projections for doubled CO2, we will enter what Colbert writes would be a completely new climate regime that human beings have never experienced. One of the experts told her that he thought it was pretty likely that unless emissions were controlled globally in a big way, fat chance under this administration, he wouldn't be shocked to find that by the year 2100, most things would be destroyed. Though he says some people wouldn't go quite that far. So with problems of that magnitude looming, and global warming is not the only one, talking about the Constitution in the year 2100 may feel a little bit like an indulgence, like rearranging the chairs on the deck of the Titanic. I told you I was going to be upbeat. But actually, it's nothing of the sort. That is, it is not futile. It's not like rearranging the chairs, because the Constitution we have, like it or not, is going to provide the broad framework within which our nation's policies will evolve and interact with the policies and constitutions of the rest of the world. And to cope with that interdependent world, we will need decision-making capabilities that transcend local bickering, that avoid the not-in-my-backyard syndrome. And we'll need arrangements for global cooperation and coordination at unprecedented levels. The good news is that absolutely nothing in our Constitution's text or design forecloses the evolution of such institutions. We were adaptable enough to weather a civil war, though we needed to amend the Constitution in the end, and thank God we did. We were adaptable enough to win World War II against global fascism. My own view is that we'll make it as long as we don't strangle our Constitution into a 19th century document to cope with 21st century problems. And there are some signs that we need to bring to the surface about whether Roberts might do that. In the case involving Congress's power to regulate commercial activity in the interest of wildlife preservation, the Rancho Viejo case, I think there are reasons for concern about how narrowly, if cleverly, Roberts described the activity that was regulated by the Endangered Species Act. He defined the activity as the, quote, taking of a hapless toad that for reasons of its own lives its entire life in California, unquote. He's full of cute things like that. They are cute in the way Scalia is cute, but without the barbs, without the nastiness. So it's going to be really effective in dealing with colleagues. He won't alienate them the way Scalia does. Now, when people express worry about that, I think it's important to be able to say clearly that doesn't mean we're looking for a judiciary that will legislate environmental protection from the bench. We're just looking for one that will let Congress legislate without imposing those 19th century formalisms. Now, here, I want to be fair here, because Doug Kendall, who knows a lot more about Roberts on this issue than I do, who is the founder and director of a major public interest firm, said last Sunday in the Washington Post that Roberts, number one, wrote the best legal brief he had ever read in a takings case, and it was a brief against the position of the property rights group that would have made regulation impossible. Roberts, in that case, was retained to argue in the Supreme Court, not for the property rights of the landowners and developers in the Lake Tahoe region, but for the Lake Tahoe Regional Planning Agency. And he won what Kendall regards as a surprising and broad Supreme Court victory that stopped the anti-regulatory takings movement in its tracks. Well, it might be a premature judgment, but so far it seems to have worked out in the Kelo case, which I'll also say a bit about in a minute. To Kendall, Roberts' work on the Lake Tahoe case shows that he has the ability to see both sides of a divisive issue and leads Kendall to think that Roberts' combination of intellect, skill, and open-mindedness should temper anxiety about his nomination. Maybe. If I were that hapless toad, I'd remain a little anxious about whether Roberts' reassuringly open and indisputably sharp mind nonetheless operates with an outdated and dangerously narrow understanding of Congress's legislative powers. So I think sharp questions about that are needed. All right. Worry number 3, things could get even worse if that narrow view of the commerce power were coupled in the same case with an equally outdated and dangerously broad definition of property rights. The Supreme Court's controversial decision in Kelo, case that upheld New London, Connecticut's taking of a private home with just compensation, as part of a comprehensive plan to redevelop the area to create more jobs and grow the economy. That case is kind of a testing case because the whole country seems to be down on Kelo. Emotionally, it's understandable. The idea of replacing a private home with a luxury estate because it's better for the economy is kind of creepy. But take my word for it, the court was applying settled doctrine when it said yes, so much so that Scalia had to join the decision by Justice Stevens. What was new was something that should have been pleasing to property owners. It was the hint in the majority opinion by Stevens, even more in the concurring opinion by Kennedy, that the Due Process Clause might impose a constraint on corrupt deals that co-opt eminent domain powers for personal gain or greed. That was a possibility that really hadn't been present in the Supreme Court's jurisprudence. And yet the business-blinded Wall Street Journal, in its editorial of July 19th, opined that the Supreme Court was, in the Kelo case, guilty of usurping legislative power. Usurping legislative power. Legislating from the bench. You've heard those accusations before. Committing the sin of judicial activism. But get real. That's 180 degrees off base. The court was applying decades-old doctrine to uphold legislative power on the part of the states, either to permit such economic development uses of eminent domain or to forbid it, as over a dozen states have. What kind of legislative power is it when you give a green light to legislatures? Worry number 4 is that Roberts could provide the decisive 5th vote to end all race-specific affirmative action. Again, in that same editorial, the Wall Street Journal called judicial activism and usurpation the Supreme Court's decision 5-4, with O'Connor casting the decisive vote in the case from Michigan Law School, upholding the individualized consideration of minority race as one factor in admissions. As I mentioned to you before, that's the case that basically used the standard that Justice Powell in the Bakke case decades earlier had articulated. But again, what kind of activism is it for a court to say that when a branch of a state university, chooses for its own reasons to use affirmative action, we'll look closely at it to make sure that it's not just stigmatizing and isn't just tokenism, but we're not going to invalidate it routinely and automatically. That's, again, letting the political process have its way. And all that liberals and progressives are asking for in that connection is let the political process have some slack when it's dealing with something as basic and difficult as the need to have minority representation at the elite levels of business and the professions and the military. Why might one worry that Roberts is not with that view? Well, the reason is that his memoirs in the Reagan White House and the Reagan Justice Department appear, so far as I've been able to tell so far, to treat all race-sensitive affirmative action as merely reverse discrimination in favor of what he derisively called inadequately prepared candidates. The one and only kind of race-sensitive government action he appeared to support in those heady Reagan years was a flat congressional ban on the use of busing to integrate schools. And now he was confronted with the awkward fact that Ted Olson, you know, that great liberal Ted Olson, had concluded in a memo to the Department of Justice when he was head of OLC that because the Supreme Court had said that you sometimes have to use busing, Congress cannot, using Section 5 of the 14th Amendment, flatly ban busing. And so what's the reaction of Roberts to that analysis? He says, first of all, Olson didn't read those cases correctly. They didn't really say that you ever had to use busing, although to the naked eye they seemed to say it. And then secondly, he said, things have changed since then. Social scientists have discovered that busing causes a backlash in the form of white flight and resegregates neighborhoods. And therefore, Congress has power under Section 5 of the 14th Amendment in the interest of long-run racial integration to ban busing that courts have found necessary to end segregation. Pretty amazing. Well, it would be kind of good news, at least on the front of a broad reading of Congress's Section 5 power, something that we've needed for a long time now with the Rehnquist court reading it so narrowly. But what it may stand for, and the tone of the memos suggests, unfortunately, that it probably does stand for instead, is a rather antagonistic attitude toward any aggressive remediation of segregation. So that's not good news. And again, liberals and progressives who worry about the attitude he showed in that case are not necessarily seeking a federal judiciary that will somehow enact their social agenda with respect to busing or school prayer or abortion. In particular, when Roberts said that it would be perfectly okay, in a very long and scholarly memo, okay to eliminate federal court jurisdiction over all of those subjects, given that the federal courts don't appear to be deciding them in a very favorable way. When he said that, he said it in handwritten form that raises some questions about his ideological neutrality on that subject. In particular, there was this colloquy. Olson said in this internal memorandum not to worry about the need to strip the Supreme Court of jurisdiction over these matters. It's probably unconstitutional. We'll be well treated in the press if we admit it and don't support these laws. That's where there was this point where Olson is greeted by a response from Roberts saying, oh, you're just kowtowing to tribe. What do you mean, well greeted in the press? But then Olson said, there are so many Republicans on the court now that it's getting more conservative all the time. Why do you want to take jurisdiction away from it? And then he lists the Republicans who were nominated. And guess what Roberts does? Roberts circles Blackmun's name. He's conservative. He circles Blackmun's name and he puts an arrow to the word abortion where it says abortion stripping, and then he puts an exclamation point. He's made his point. He says you can't rely on the conservatism of the courts. They're not going to apply the Constitution. That, of course, gives people some sense that maybe there's a belief on Roberts' part that Roe v. Wade was wrong. Doubt that he'll say that. And of course, he could believe it's wrong and also not believe that it should be overruled. So there are layers upon layers through which the smoke has to pass. But that leads to worry number 5, that he would take a narrow view of reproductive rights, of sexual privacy, of personal autonomy, of liberties that are not explicitly guaranteed and that were not taken for granted specifically in 1787 and in 1868. And why might one worry about the narrowness of his view on those matters? Well, again, I can't go through all the memos, but there's a decision you should be aware of if you haven't read it. It's the Hedgepeth case, which was decided last October And it rejects the constitutional challenge brought by and on behalf of a 12-year-old girl who was arrested, incarcerated, and humiliated under a District of Columbia policy that for a short time mandated the arrest of any minor for eating anything, even as in the case of this young woman of 12, a single French fry at a subway stop. She ate a French fry. Terrible. And there was no discretion. She had to be arrested. She was put in a van, she couldn't see anything, no windows. She was taken to the station, made to take off her shoes, untie the shoelaces, got a record. I mean, she wasn't beat up. She wasn't tortured. She wasn't positively abused in any way, but this was a pretty serious intrusion. Roberts' opinion in that case, which, by the way, rejects her challenge, says there was nothing unreasonable under the Fourth Amendment with a policy of mandating arrest in all such cases. His opinion proceeds as though he thinks it's absolutely vital to shut down all human feeling when one thinks like a lawyer. It's reminiscent of what Rehnquist, his former boss, wrote in the famous case of poor Joshua, a kid who was beaten into a pulp by his father while the social workers stood by, and the mother brings a suit against the social workers, and Rehnquist says, that the social workers didn't do the beating. They were the state. The father wasn't the state. It's all very legalistic and very nice. But the key language there in the opinion is judges and lawyers, like other humans, are moved by natural sympathy. And that was kind of the giveaway. That is, like humans, we are moved by sympathy, but we're not supposed to be that way when we think like lawyers, even though we're interpreting a word as flexible as unreasonable. No, like lawyers, we have to look at what things were like in 1791 when the Fourth Amendment was ratified. And sure enough, there is language in this very recent opinion by Roberts saying exactly that. It says that we're sorry for this little girl, nobody likes what happened, but back in 1791, she wouldn't have had these rights. And I just wonder, is that how he really thinks about these things? He's joined by two other quite conservative judges on the D.C. circuit, but I think there's reason to worry. It's also reason to worry from how he uses precedent. He points to an earlier decision of the U.S. Supreme Court involving a woman who was arrested for not wearing a seatbelt and letting her kids not be seatbelted under a discretionary arrest policy where you can arrest people for violating the seatbelt laws. And the Supreme Court, 5-4, upheld that arrest. By the way, in that case, O'Connor, whom he's replacing, wrote an impassioned dissent, thinking it was outrageous that she should be arrested for that. But the fact that the court in Atwater, that earlier case, had upheld a discretionary arrest for leaving your children unseatbelted is treated by Roberts as mandating the conclusion, leaves him no choice. He can't help it. It's got to be human feeling here, but we're lawyers. I have to conclude from this other case that a mandatory policy of arresting a child for eating a French fry is okay. Well, that follows only through a badly programmed form of logic, and I'd be interested in seeing how he got from A to B and why one shouldn't worry about his view of liberty. Well, I guess I've gone way too long. I clearly have to stop. I was going to talk. I think I can do it quick. I'll tell you the gist of it. I was going to talk about how in the original case where the Supreme Court launched this idea that you're not supposed to feel anything when you decide, it was a case I found in 1814 where they said that we have to really think like lawyers, but the next line wasn't, we therefore have to go back in time. It was to look at how other countries in the world dealt with this problem. And I was just sort of thinking, it's been a little while since we've been reminded that the practice of looking elsewhere in the world, the way Justice Breyer did in the case where the majority struck down the requirement that local law enforcement officers do a background check on police. The majority, in an opinion by Scalia, said that this violated, no nothing in the Constitution's text, but a structural presupposition that says, in the name of federalism, that the national government cannot impose enforcement duties on local enforcement officers. And in that case, Breyer says, well, there are other countries like Switzerland and Germany that have struggled with the problem of federalism, and it's interesting to see how they deal with it. The way they've dealt with the problem of preserving localism while maintaining control of the center is by resisting having lots of federal bureaucrats crawling all over the country. They don't think that serves the interest of localism. They mandate that the local units carry out certain federal responsibilities. And federalism doesn't seem to have suffered there. It's kind of an empirical inquiry, looking at it to see how it works elsewhere. But Scalia gets on a high horse and says, this is the Constitution of the United States of America. What are you doing looking abroad? And so I wanted to then see, not only did the court used to do it in the 1800s, what about Scalia? I thought maybe he's done it. And sure enough, in a case involving elections, in the McIntyre case just a few years ago, Scalia says in England, this is a dissenting opinion on his part, he says in England and in Canada and in Australia, they forbid anonymous campaign literature. So why are you so sure that the First Amendment has to be construed in the way you construe it, he says to the majority, namely to permit anonymity? Scalia has also, in other cases, joined opinions that did this, that looked abroad, one by none other than Chief Justice Rehnquist. Rehnquist in the Glucksberg case, Washington against Glucksberg, the case involving whether there is a right to physician-assisted suicide, the opinion carefully looks at what happened in the Netherlands with physician-assisted suicide, says there was some abuse there. And you could say, well, he's just looking at it for empirical purposes. That didn't save Breyer from a scathing attack in the case involving the gun checks. And in fact, he wasn't just looking to it for empirical purposes. The main point Rehnquist is making in the text is, he says, virtually every other Western democracy bans physician-assisted suicide, makes assisted suicide of all types a crime. And he uses that to argue that we likewise should not regard ourselves as unreasonably restricting liberty if we make it a crime. He's looking at the practices of other countries as is entirely reasonable, not just for empirical purposes, but for normative purposes. And I could go on. There are, it turns out, dozens of examples throughout our history from the 1800s to the present where both for empirical purposes and for normative purposes, we act as though we're part of one world. That is, we say we can learn something from other countries. We can't expect them to treat us very well if we pay no attention to what they do. One would think that that is as true today as it was in the 1800s, truer perhaps, when we have to deal with global problems as serious as terrorism and as ultimately serious as global warming. One would think it's important still to be part of a single world. And yet, in 2003, Robert Bork wrote a book called Coerced Virtue about the rule of judges, in which he says that the reason, now get this I think has become the source of lots of talking points for conservatives. The reason that liberals now want to refer to foreign judgments and foreign law, and it has been mostly the liberals who've defended the practice. Breyer goes on TV and debates Scalia and defends it. O'Connor gives a speech defending it. Ginsburg, in her speech from this podium 2 years ago, defended it. They're upfront about defending it. Conservatives just do it. And when liberals do it, they attack them. And when Bork wrote Coerced Virtue, he said that the reason this happens is that liberals have, since they can't win elections, since their values are so off, they've got to get their values in through the judiciary. And they can't do it directly, so they plant them abroad by having these judges abroad get in the thrall of a mandarinate of anti-religious, socialist, faux intellectuals who can be manipulated into citing American decisions and making Americans feel they have to cite their decisions. It's all part of a vast left-wing conspiracy that we've got. Because our program is to take over the country through social engineering, through the courts. You know, I've heard that so often that I've forgotten what the best answers are. The best answers are, it's bull. That is, what is our program? Our program is health insurance, better jobs, better environment, more equitable distribution of wealth. It's nothing too fancy. We're not very good at describing it, but that's the program. And that's not something we try to do through the courts. It's something we should be trying to do by getting our people elected. And we have tried, but not very successfully. But we don't try with the courts. With the courts, we have rather more modest ambitions, like preventing torture, even when the president says it's a good idea. More modest ambitions like avoiding discrimination based on race, even when it's harder to prove intent, or avoiding discrimination based on sexual orientation. Take that one. They claim that the gay rights decisions are part of an agenda to transform the culture and win the culture wars in the courts. But even the most extreme of the gay rights decisions, like saying same-sex marriage must be provided if you have marriage at all, are simply non-discrimination decisions. You may think they're wrong, or you may think they're right. You may think they're right, but tactically premature. But one thing they're not is attempts to re-engineer the society through judicial decree. Maybe you could say that in the most heady days of the Warren era, when courts played a very dramatic quasi-managerial role in implementing the remedies to some of their decisions that maybe looked like they were crossing some line between management and politics on the one hand and the pronunciation of principle on the other. But otherwise, it's simply to exercise a veto over assaults on decency by government, which is why we look around the world, because we are all part of the human race, and it's relevant what other people think are fundamentally indecent. So that when the court says that virtually no other country executes the mentally retarded, and when Stevens uses that as an added reason to confirm his conclusion in Adkins, it's ludicrous to attack him for somehow binding America with foreign law. First of all, he's not binding anybody, he's just using it in a confirmatory way. And secondly, that's not part of some social program. He's simply saying, in deciding what's decent and what's indecent, we look around, the way Rehnquist did with respect to physician-assisted suicide, or when the court more recently, in an opinion by Kennedy, after concluding that it was fundamentally indecent to execute juveniles, finds confirmatory evidence elsewhere in the world, and Scalia accuses him of trying to remake the nation in the image of Europe. It just doesn't connect. He's not remaking the nation. He's applying the cruel and unusual punishment ban, and he's doing it through a methodology that's well established. So it's a bum rap. They are very good at selling it, but it's a bum rap. But the reason it's a bum rap is the reason I'm optimistic, and that's where I want to close. I'm not so optimistic about stopping nominees who are pretty much what people should have expected from this crew, and better, in fact, than what most of us feared. I'm not optimistic about being able to do that. I'm not optimistic in the short run about having a Supreme Court that is predictably an ally, but not an ally in the effort to re-engineer the country, just an ally in the effort to maintain decency. I'm not optimistic about that. But I am optimistic that if we remember that work at the ground roots is where it all began anyway, that things like the movement for racial and gender equality didn't begin with having a Thurgood Marshall sympathetically on the court or a Ruth Bader Ginsburg on the court, but began with decades of hard work at the grassroots. And if you want to see how it was structured, just read some of the wonderful articles by Reva Siegel on the development of the women's movement. That's where it started. Major social movements of a progressive and liberal sort are advanced through a complicated interaction of law and political action. And there's no reason to doubt, no reason at all to doubt that we are still potentially capable of that, that that's where the future lies. And if we do it, one of the side benefits of the more progressive presidents and senators that we elect, one of the side benefits will be that some of you eventually happen to sit on the court instead of some of them. But that's not the only way to get there. That's just a side effect. Thank you very, very much.